Hello friends, welcome to Analytics IS Academy and our YouTube channel Let's Crack IS Analytics IS, where we have been doing a series of lectures targeting UPSC CSC Prelims 2020, in which we are covering those topics which are important topics, those topics which require more conceptual clarity, more understanding. So from that perspective, we started this particular crash course to help you student to develop a better understanding about those 500 700 topics from where repeatedly UPSC has been asking question. In this particular session of Indian polity, I myself is taking number of areas of Indian polity and constitution which are important areas from prelims point of view. In that we have already covered a number of such important areas from your polity and constitution part, like we have discussed historical evolution of Indian constitution, we have discussed preamble to Indian constitution, citizenship, fundamental right, we have discussed directive principle of state policy, fundamental duties, and then we entered into part 5 of Indian constitution that deals with union government. In that we have already discussed union executive, that is president and council of minister. So friends, here our main motive is to cover those areas which are important areas from your prelims point of view, and one such important area that is important, that is from where UPSC has asked questions repeatedly in last few years, that is Supreme Court of India. And this particular area of your syllabus, considering its importance, considering its voluminous nature, I'm going to cover this particular aspect in two sessions of 1 hour each, where I will try to cover each and every aspect of our Supreme Court of India, considering its importance from your examination point of view and otherwise also. So in this particular session, I'm going to cover what is the genesis and role of the Supreme Court, जहाँ पे हम जानने की कोशिश करेंगे हिस्टोरिकल ओरिजिन के बारे में, कैसे आइडिया ऑफ सुप्रीम कोर्ट केम इनटू एग्जिस्टेंस, what is the role of Supreme Court from the functioning democracy like India. Then we will try to understand most important aspect related with Supreme Court, and I'm emphasizing it again and again that in case of appointment of president, in case of appointment of prime minister, in case of appointment of अदर मेंबर ऑफ काउंसिल ऑफ मिनिस्टर, शायद मैंने 2 मिनट का ही टाइम आपको के साथ स्पेंड किया होगा, बट दिस पर्टिकुलर एस्पेक्ट, दैट इज अपॉइंटमेंट ऑफ जजेस ऑफ सुप्रीम कोर्ट, दैट इज वन such aspect where I'm going to take almost 35 to 40 minutes from crash course point of view. Otherwise I would have taken almost 1.5 hour for this particular aspect only, because it is one important aspect. And in case of appointment of judges of Supreme Court, I'm saying this process has evolved over a period of time in last 70 years of functioning of Indian Constitution. So with regard to appointment of judges of Supreme Court, I will discuss evolution process of appointment process, or how it got evolved, जहाँ पे हम डिस्कस करेंगे आर्टिकल 124, जहाँ पे कॉन्स्टिट्यूशनल मेंशन है रिगार्डिंग जजेस के अपॉइंटमेंट का. देन फर्स्ट जजेस केस आई विल डिस्कस, सेकंड जजेस केस, थर्ड जजेस केस, एंड लेटर ऑन आई विल आल्सो डिस्कस fourth judges case also. And in that discussion we will try to reach the present situation, that how judges they themselves are appointing judges or collegium system. In between there will be certain factual information also, like qualification for judges of Supreme Court, oath of judges of Supreme Court, their terms of judges of Supreme Court. So ये जो aspect हैं, they are largely factual, not much concept is involved, but from your information aspect I have mentioned these things. Then another important thing that I am going to discuss in this particular session, that is removal of judges of Supreme Court. That is again where you need to develop some sort of conceptual clarity. Many times the word impeachment is used in case of Supreme Court judges, so we will try to understand why such confusion is there, that in constitution it has been mentioned removal of judges of Supreme Court, but many times when you appear in some test series or you solve questions, this word impeachment you may find in case of judges of Supreme Court and High Court. So all these aspects I am going to discuss in this particular session of 1 hour. So सबसे पहले I am going to discuss with you people genesis of Supreme Court, कि कैसे Supreme Court का genesis हुआ, इसका origin, and what is the role of what Supreme Court for a country like India. So if you trace a genesis of Supreme Court, then first mention of Supreme Court in your history you will find through Regulating Act of 1773. So while discussing with you people historical evolution of Indian Constitution, already I discussed about Regulating Act of 1773 और किस तरह से इस एक्ट के थ्रू कंपनी के मैटर्स में ब्रिटिश पार्लियामेंट का इंटरफेरेंस स्टार्ट होता है. सो पहली बार जो मेंशन मिलता है सुप्रीम कोर्ट का आपको इंडियन हिस्ट्री में, दैट इज इन regulating act of 1773. But at that time only I discussed with you people that Supreme Court, its jurisdiction was limited till Calcutta presidency, and it will take up the cases only those people who were native Britishers. जो नेटिव ब्रिटिशर्स थे, नेटिव इंग्लिश पीपल थे, उन्हीं के केसेस पे जुरिडिक्शन था सुप्रीम कोर्ट का. ये बात हमने आपके साथ तब भी डिस्कस की थी व्हेन आई वाज डिस्कसिंग विद यू पीपल रेगुलेटिंग एक्ट ऑफ 1773. देन सेकेंड important aspect with regard to evolution of judicial system in India was Charter Act of 1861, through which number of high courts were established in India in different presidency town. Then for the first time in Government of India Act 1935, अगर आपको याद होगा वो हिस्टोरिकल इवोल्यूशन वाला चैप्टर जो मैंने आपके साथ डिस्कस किया था, कि यहाँ पर पहली बार मैंने आपके साथ बात की थी फेडरल कोर्ट की. माइंड इट, आई एम सेइंग फेडरल कोर्ट, आई एम नॉट सेइंग सुप्रीम कोर्ट, बिकॉज दिस सुप्रीम कोर्ट को आप जानते हैं, हम जानते हैं आज की डेट में, that is the highest court of appeal in India. So the present day Supreme Court that is existing in independent India, that is the highest court of appeal in case of all civil, criminal and constitutional matters. There is no court above Supreme Court in case of India. Supreme Court of India अपने ही जजमेंट को रिवाइज कर सकते हैं, क्यूरेटिव पिटिशन कैन बी फाइल्ड, दैट इज अनदर थिंग. बट इंडिया में कोई और कोर्ट नहीं है अबव सुप्रीम कोर्ट. सो देयर इज नो अपील अगेंस्ट द जजमेंट ऑफ सुप्रीम कोर्ट इन फ्रंट ऑफ एनी अदर कोर्ट. सो हियर इन दैट कैपेसिटी वी आर रेफरिंग इंडिपेंडेंट इंडियन हाईएस्ट कोर्ट एज सुप्रीम कोर्ट. बट ये जो फेडरल कोर्ट इस्टेब्लिश हुआ है दैट केम इन टू एग्जिस्टेंस इन 1937, इसके जजमेंट के अगेंस्ट में आप प्रिवी काउंसिल में सामने भी जा सकते थे. दैट वाज द हाईएस्ट जुडिशियल बॉडी in context of England at that time. So the kind of the federal court that we are establishing through Government of India Act 1935, that cannot be regarded as highest court of appeal if you compare it with the present day Supreme Court, which is the highest court of appeal in territory of India on all civil, criminal and constitutional cases. So the first such Supreme Court of independent India came into existence on 28th January 1950. This thing you need to remember, even though UPSC rarely asks such factual questions, but I tried to mention it as an evolution of what Supreme Court, considering importance, significance, role of Supreme Court in an independent India. So your Supreme Court as you see today, it came into existence 2 days after commencement of your constitution. So your constitution came into existence commencement on 26 January 1950, and Supreme Court was established on 28 January 1950. This aspect was related to origin or genesis of Supreme Court. So in constitution where you can find mention of Supreme Court, so first mention which is mentioned in constitution or constitutional mention of Supreme Court you may find in article 124 of Indian Constitution, where article 124 of Indian Constitution says that there shall be a Supreme Court of India. So under article 52 हमने आपके साथ डिस्कस किया, there shall be a President of India. Under article 74 हमने आपके साथ डिस्कस किया, there shall be a Council of Ministers headed by Prime Minister. In a similar manner, article 124 is talking about this particular institution, that is Supreme Court of India, where it is saying that there shall be a Supreme Court of India consisting of what? consisting of a Chief Justice of India and any other number of judges that Parliament may by law prescribe from time to time. So at the time of commencement of Constitution, you are saying there shall be a Supreme Court of India consisting of Chief Justice of India, and until Parliament may by law, mind it, Parliament may by law prescribe a larger number of not more than 7 other judges. So at the time or at the time of establishment, total number of judges were 1 plus 7, that is 1 Chief Justice of India and 7 other judges, and this number can be increased, mind it, not by President, this number can be increased by whom? Parliament may by law. So you have to keep in your mind that Parliament may by law can increase number of judges in Supreme Court or High Court, and last such law that Parliament has made while increasing number of judges in Supreme Court was in 2019 when they came up with Supreme Court number of judges Amendment Act 2019, जिसके थ्रू नंबर ऑफ जजेस की स्ट्रेंथ को 30 से बढ़ाकर 33 कर दिया गया. बट अगेन आई एम सेइंग फॉर इंक्रीजिंग नंबर ऑफ जजेस इन सुप्रीम कोर्ट यू नीड नॉट टू ब्रिंग एनी अमेंडमेंट, एंड बिकॉज ऑफ दैट in original article 124 even today this number is mentioned 1 plus 7, and that's why it is there on your screen कि अगर आप जजेस का नंबर बढ़ाना चाहते हैं उसके लिए आपको कोई कॉन्स्टिट्यूशनल अमेंडमेंट लाने की ज़रूरत नहीं है. बट येस, इफ़ यू वांट टू चेंज द मेथड ऑफ अपॉइंटमेंट ऑफ जजेस, इफ़ यू वांट टू चेंज पावर्स एंड फंक्शंस ऑफ द सुप्रीम कोर्ट, देन यू आर सपोज टू ब्रिंग एन अमेंडमेंट. उसके लिए आपको कॉन्स्टिट्यूशनल अमेंडमेंट लाने की ज़रूरत है. दिस थिंग यू हैव टू कीप इन योर माइंड कि नंबर ऑफ जजेस को इंक्रीज करने के लिए थ्रू ऑर्डिनरी लॉ यूनियन पार्लियामेंट they can increase number of judges in Supreme Court and High Court, and for that purpose there is no need of what any constitutional amendment. But yes, if you want to change the method of appointment of judges, if you want to change powers and functions of what Supreme Court of India, then you need to bring what a constitutional amendment act. And because of that, even today in article 124 the number is mentioned as 1 plus 7, which was there at the time of commencement of what constitution. भले ही number of judges बढ़ चुके हैं 33 तक, so from 7 it is still 33, but in constitution it is mentioned 1 plus 7, क्योंकि number of judges को बढ़ाने के लिए कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट लाने की ज़रूरत नहीं है. सो आई होप ये चीज़ आपके माइंड में क्लियर हो रही होगी. देन मोस्ट इंपॉर्टेंट थिंग with regard to this particular aspect of Supreme Court that I am going to cover in this session, that is process of appointment of judges of Supreme Court. जहाँ पे मैंने आपके साथ डिस्कस किया कि बाकी कॉन्स्टिट्यूशनल डिग्निटरीज के केस में, प्रेसिडेंट के केस में, वाइस प्रेसिडेंट के केस में, काउंसिल ऑफ मिनिस्टर के केस में हमने बहुत कम टाइम स्पेंड किया द मैनर इन विच दिस कॉन्स्टिट्यूशनल डिग्निटरीज आर अपॉइंटेड. बट हियर ऑन योर स्क्रीन यू विल फाइंड दैट this process I am referring as evolution of process of appointment of judges of Supreme Court. So it has evolved. So at the time of commencement of Constitution, Article 124, as it was there, it was saying that executive had final say in appointment of judges of Supreme Court and High Court and transfer of judges of High Court. But from that point, it has reached to a situation where now a collegium system I will explain later on, in which there will be judges themselves, CJI plus other judges of Supreme Court. A collegium system was evolved through the hands of judiciary themselves. So judiciary themselves created a kind of system known as collegium system, where judges will appoint judges. So in case of MLAs, in case of MPs, you will not find that MLAs are appointing MLAs or MPs are appointing MPs. But here a process of appointment of judges which started from one point, that is in 1950, where president is the head of executive who used to work on the advice of council of minister. They had final say in appointment of judges, और वहाँ से ये प्रोसेस पहुँच चुका है collegium system में, जहाँ पे one CJI plus 4 other senior most judges, they will recommend a name and that person will be appointed as a judge of Supreme Court. So from that point till this point, this journey we will try to understand. कि how this process of change took place, how that appointment process got evolved from Article 124 till फोर्थ जजेस केस 2015, जिसके बीच में एक जगह पे मेंशन आएगा नेशनल जुडिशियल अपॉइंटमेंट कमीशन एंड जैक, जिसकी कोई मीटिंग भी नहीं हो पाई, एंड इवन बिफोर दैट it was declared illegal and unconstitutional. So these things we will try to understand कि executive had final say in appointment of judges, till judges will have their final say in appointment of judges, how this process got evolved, and for that purpose we need to understand appointment of judges of Supreme Court, कैसे Supreme Court में judges को appoint किया जाता है. This thing we need to understand, and for that purpose for the first time or on your screen you may see Article 124. और Article 124 बहुत ही clearly बोल रहा है the President appoints CJI, and while appointing CJI he may or may not consult other judges of Supreme Court. So जब भी President CJI को appoint करेंगे he may or may not consult other judges of Supreme Court. However, while appointing other judges of Supreme Court, President shall consult CJI. He may also consult such other number of judges from High Court and Supreme Court that he may deem fit. So originally Article 124 clause 1 was saying that it is the head of the executive, President of India, who is going to appoint CJI, and आप CJI को बोल सकते हैं head of judiciary in India. So on your screen through this diagrams I try to explain that what Article 124 clause 1 was saying. Article 124 clause 1 was saying that it is the President who is the head of executive, who work on the advice of Prime Minister and Council of Minister, और Prime Minister और Council of Minister के members they are either member of Lok Sabha or Rajya Sabha. So you may see in this manner कि legislature and executive in close collaboration they are appointing Chief Justice of India, because President appointing Chief Justice of India on the advice of a real executive, that is Prime Minister and Council of Minister, जिसके members या तो लोक सभा के member हैं या तो राज्य सभा के member हैं. So executive in close collaboration with legislature they are appointing head of judiciary in India known as CJI. And Article 124 was saying that when President appoints CJI he may or may not consult other judges of Supreme Court. But while appointing other judges of Supreme Court, on your screen you may see President shall consult CJI. So Constitution was saying while appointing CJI President may or may not consult other judges of Supreme Court, but while appointing other judges of Supreme Court President shall consult CJI. That was the situation in original Constitution. Constitution does not have any direct reference कि who can become CJI, who can be appointed as CJI. So among these 33 judges, suppose अगर present CJI retire हो रहे हैं तो इन 33 में से किसे CJI बनाएंगे president, what qualification that person should have, then only he will be appointed as CJI. इस पे Constitution silent है, and because of that, since Constitution was silent on this particular issue, एक कन्वेंशन इस्टेब्लिश हुआ, एक पॉलिटिकल प्रैक्टिस इस्टेब्लिश हुई कि सीनियर मोस्ट जज को अगला सीजीआई बनाया जाएगा. सो वेयर एवर कॉन्स्टिट्यूशन इज नॉट क्लियर, political executives or member of legislature they came up with some conventions, some practices, because in absence of such constitutional provision, in absence of such constitutional convention, there can be arbitrariness, और ऐसी arbitrariness ना हो इसलिए एक पॉलिटिकल प्रैक्टिस इवॉल्व की गई 1950-51 में ही कि अमंग ऑल दीज अदर जजेस सीनियर मोस्ट जज विल बी अपॉइंटेड एज सीजीआई. बट इस सीनियरिटी प्रिंसिपल का दो बार वॉयलेशन हुआ. 1973 में इन केस ऑफ जस्टिस ए एन रे ही वॉज अपॉइंटेड एज सीजीआई वाइल सुपरसीडिंग 3 सीनियर मोस्ट जजेस ऑफ सुप्रीम कोर्ट. 3 सीनियर मोस्ट जजेस को इग्नोर करके जस्टिस ए एन रे को चीफ जस्टिस ऑफ इंडिया बनाया गया. एंड देन अगेन इन 1977 व्हेन जस्टिस एम यू बेग ही वॉज अपॉइंटेड एज सीजीआई. सो दीज वर 2 इंस्टेंसेस व्हेन seniority principle was violated, and this was a time period from 1970 to 1977 when there was a kind of tussle, there was a kind of conflict between judiciary and executive. क्योंकि अगर आप शुरू की इंडियन पार्लियामेंट को देखें, द काइंड ऑफ द एग्जीक्यूटिव देखें, लाइक फॉर्मर प्राइम मिनिस्टर जवाहरलाल नेहरू, सरदार पटेल, डॉक्टर राजेंद्र प्रसाद, तो ये वो लोग थे. They were the first generation leader of this independent India, those who fought freedom struggle, those who have shown their credential for democratic standards. They fought for these values, that judiciary should be independent. So from 1950 till 1970, this kind of the consultation between President and CJI in case of appointment of judges of Supreme Court, in case of appointment of judges of High Court, in case of transfer of judges of High Court, it was smooth process because executive, they knew the importance of independent judiciary for a such functioning democracy like India. But 70 से 77 का वो जो time period था, there were lots of tussle between executive and judiciary. Many times seniority was ignored and junior judges were appointed as CJI. और यही एक केवल अबेरेशन नहीं था, कई बार जजेस का मास ट्रांसफर हुआ फ्रॉम वन हाई कोर्ट टू अनदर हाई कोर्ट. सो यू नीड टू अंडरस्टैंड दैट इवन दो दीज जजेस दे आर एट द पे रोल ऑफ गवर्नमेंट, बट ये सरकारी जजेस नहीं है. सो कॉन्स्टिट्यूशन मेकर्स दे वांटेड ए काइंड ऑफ जुडिशरी दैट विल बी कमिटेड टू लॉ, कमिटेड टू जस्टिस, जुडिशरी not that will be committed to government of the day, because the kind of the separation of power हमने आपके साथ डिस्कस किया, where the role of judiciary was to adjudicate over legislature and executive, and there were number of complaint, lots of debate was going on in India from 70 to 77, and such debate finally reached till Supreme Court, and one such case was filed known as SP Gupta versus Union of India case 1982, जिसमें SP गुप्ता का कहना है कि when president is appointing other judges of Supreme Court and when he is having consultation with CJI, what is the nature of consultation? What does consultation means when president consults CJI while appointing Mr. X and Mr. Y as a judge of Supreme Court? So ऐसा तो नहीं कि president जैसे एक phone call कर रहे हैं CJI को और बोल रहे हैं कि मैं मिस्टर एक्स और मिस्टर वाई को सुप्रीम कोर्ट का अगला जज बनाने वाला हूं, आपका क्या कहना है? सो व्हाट डज कंसल्टेशन मीन्स? कंसल्टेशन मीन्स कंकरेंस ऑफ सीजीआई और नॉट. सीजीआई का ओपिनियन while appointing any person Mr. X और Mr. Y as a judge of Supreme Court, ये प्रेसिडेंट पर बाइंडिंग है या नहीं है? This question was raised before Supreme Court for the first time in this case known as SP Gupta versus Union of India case, जिसको हम फर्स्ट जजेस केस भी बोल रहे हैं. In this case, Supreme Court held that any such opinion expressed by CJI in case of appointment of judges of Supreme Court is not binding on president. Constitution makers, they have mentioned a term consultation, and consultation means exchange of ideas, exchange of viewpoint between president, who is the head of the executive, and CJI, who is practically head of the judiciary in India. So such consultation or such opinion expressed by CJI is not binding on president. Yes, any such consultation should be meaningful. So Supreme Court in this case held that consultation should be meaningful. Meaningful से मतलब ये है कि all material fact, all data regarding qualification of the person under consideration, that should be made available to CJI. So अगर Mr. X और Mr. Y को प्रेसिडेंट जज ऑफ सुप्रीम कोर्ट बनाना चाहते हैं तो उनका जो भी एकेडमिक रिकॉर्ड है, द काइंड ऑफ द जजमेंट दे हैव डिलीवर्ड, that clearly establishes that they are the distinguished jurists of India, that file should be made available to CJI so that एक meaningful opinion CJI दे सकें प्रेसिडेंट को. हालांकि ये ओपिनियन प्रेसिडेंट पर बाइंडिंग नहीं होगा. दिस वॉज द जजमेंट इन केस ऑफ SP Gupta versus Union of India case. Means till 1982 also executive will have their final say in appointment of judges of Supreme Court. But in another case known as Supreme Court Advocates on Record Association versus Union of India case 1993. So friends, 1993 is a landmark year in case of independence of judiciary in India. So remarkable difference in pre 1990 years and post 1993 year. Pre 1993 year, executive they had final say in appointment of judges of Supreme Court and High Court. But in this case, Supreme Court of India, they came very heavily while seeking independence, and they tried to carve out a kind of mechanism for judicial independence in case of appointment of judges of Supreme Court. And here they are saying consultation means concurrence. So Supreme Court, while being as interpreter, final interpreter of Constitution, Supreme Court का कहना है कि process of appointment of judge of Supreme Court is a process to find out best possible judicial talent in India, and this process is integrative, participatory and consultative. Integrated, participatory and consultative का मतलब है कि in this process of finding out best possible judicial talent in India, all three organs, executive, legislature and judiciary, all three organs of government, they are participating, but primacy should be given to opinion expressed by CJI, because opinion of CJI is not his personal opinion. Opinion of CJI is the collective opinion of Indian judiciary as such, and therefore while while formulating his opinion, CJI must consult two senior most judges of Supreme Court. So Chief Justice of India, while in consultation with two senior most judges of Supreme Court, ये जिस नेम को फॉरवर्ड करते हैं, दैट नेम प्रेसिडेंट शुड अपॉइंट एज अ जज ऑफ सुप्रीम कोर्ट, एंड फॉर द फर्स्ट टाइम दे केम अप विद द सीनियोरिटी प्रिंसिपल दैट अनलेस अदरवाइज रिक्वायर्ड, senior most judge of Supreme Court will be appointed as next CJI. So they tried to remove any doubt, any confusion regarding who will be the next CJI of India, Chief Justice of India. And while appointment of judges of Supreme Court, for the first time they came up with a collegium system, that is CJI plus two senior most judges. If they will forward a name in form of their opinion, that opinion will be binding on President of India. In case of any conflict between constitutional dignitaries, that is President, Council of Ministers on one side and CJI plus these two senior most judges on the other side, then President may send back this opinion for one more reconsideration. But after such a reconsideration, if same opinion is forwarded to President, then it will be binding on executive. So for the first time, judiciary took it upon themselves that they will appoint the judges, and in 1998 the presidential reference was made to Supreme Court in case of appointment of judges of Supreme Court. That case was referred as reappointment of judges case 1998, and in this case CJI or Supreme Court of India, they upheld the last judgment, but they expanded the scope of collegium, size of collegium, and in this case they held not just two senior most judges, but CJI in consultation with four senior most judges. If they will forward a name, then that name will be binding on executive. Maximum executive can do that, they can send back that name for one more reconsideration. But after such reconsideration, if same name is forwarded again to executive, then that name will be binding on executive. So the process that started from Article 124, which was saying that President will appoint CJI and other judges of Supreme Court, here it reached to a point where judges, they came up with the kind of collegium system consisting of CJI plus four other senior most judges. So judges themselves will appoint judges, or judges will be appointed by judges. सो हमने आपके साथ जब सेपरेशन ऑफ पावर डिस्कस किया, थ्योरी ऑफ सेपरेशन ऑफ पावर विच वाज गिवन बाय मॉन्टेस्क्यू, वी टॉक्ड अबाउट एग्जीक्यूटिव, लेजिस्लेचर एंड जुडिशरी, और हर किसी की अकाउंटेबिलिटी किसी न किसी के प्रति है. लाइक एग्जीक्यूटिव दे आर अकाउंटेबल टू लेजिस्लेचर, हमने नो कॉन्फिडेंस मोशन की बात की, मनी बिल की बात की. एग्जीक्यूटिव्स दे आर अकाउंटेबल टू वोटर्स ऑल्सो, पीपल हु इलेक्टेड देम, हु वोटेड देम टू पावर, and executives they are also answerable to judiciary. In a similar manner, legislature they are answerable to voter as well as judiciary. But what about judiciary? If judges themselves will start appointing judges, so there can be nepotism in appointment of judges. There can be secrecy in appointment of judges. So a debate started against such collegium system. Ki independence of judiciary is fine, but independence of judiciary should be balanced with credibility of judiciary also. Such secrecy, such opaque nature of the appointment of judges, it may lead to more nepotism in appointment of judges, and we may not be able to get best possible judicial talent in India. So we may get good judges, but we were looking for what? The best possible judicial talent of country. So a commission which was there to review the functioning of Indian Constitution, headed by Justice Venkat Chaleya, it also recommended that in case of appointment of judges of Supreme Court, there should be some judicial appointment committee. And all these debate, all such suggestions, they led to 99th Constitutional Amendment Act 2014, where 99th Constitutional Amendment Act 2014, for the first time it came up with the body National Judicial Appointment Commission. And National Judicial Appointment Commission tried to make this process integrative, participatory and consultative, where it is saying that there will be a 6-member body headed by Chief Justice of India, consisting of 2 other senior most judges of Supreme Court, Law and Justice Minister, and 2 distinguished jurists, 2 eminent persons who will come from civil society, and those 2 names will be nominated by a committee of 3 members, जिसमें CJI भी हैं, Prime Minister भी हैं और Leader of Opposition in Lok Sabha भी हैं. So it was argued that perhaps this would be the best body to find out the best possible judicial talent in India, because it is giving representation to judiciary also, it is giving representation to Law and Justice Minister also, he is also part of legislature also, and it is also giving representation to civil society, where 2 eminent persons belonging to the field of law will be nominated by a committee consisting of CJI, Prime Minister and Leader of Opposition in Lok Sabha. So NJAC was proposed as a body which will look into matter related to appointment of judges of Supreme Court and High Court. But this formulation of NJAC challenged in 4th Judges Case 2015, in which Supreme Court of India held 99th Constitutional Amendment Act as illegal and unconstitutional, and we came back to collegium system, where present situation is that the CJI, in consultation with 4 senior most judges, they will initiate a name for judge of Supreme Court, and that name will be binding on executive, and that name should be appointed. So this process, which is not mentioned in Constitution, that got evolved through the hands of Supreme Court itself. So Constitution में आर्टिकल 124 मेंशन है, जो ये बोल रहा है कि प्रेसिडेंट ऑन द एडवाइस ऑफ काउंसिल ऑफ मिनिस्टर विल अपॉइंट CJI एंड अदर जजेस ऑफ सुप्रीम कोर्ट. While appointing other judges of Supreme Court, President may consult CJI. But on nature of consultation, lots of debate was there, lots of confusion was there, and such debate, such confusion, when executive many a times tried to erode, tried to interfere, tried to encroach in judicial independence. So finally judiciary, they themselves came forward and they fought for their independence and tried to carve out a distinct mechanism. This mechanism I am referring as this collegium system, where judges will be appointed by judges themselves. So present process of appointment of judges of Supreme Court in a short, in a brief, if I try to explain you. So आपकी स्क्रीन पे आप देख सकते हैं कि चीफ जस्टिस ऑफ इंडिया इस प्रोसेस को इनिशिएट करते हैं आफ्टर कंसल्टेशन ऑफ minimum 4 senior most judges of Supreme Court. This name will be forwarded to Law Ministry. If they have any kind of reservation about that name, this name can be sent back for reconsideration. After reconsideration, if the same name is forwarded, then the name will be sent to Prime Minister's office, and from Prime Minister's office that name will be sent to Judge of Supreme Court or High Court. That is the process. Through these procedural mechanism, a person is appointed as a Judge of Supreme Court or High Court. but हमने आपके साथ through these 4 cases we try to understand that how this process of appointment of judges of Supreme Court got evolved from where executive they had final say in appointment of judges of Supreme Court till a point where now judiciary will have their final say in case of appointment of judges of Supreme Court. So what can be the qualification to be appointed as जज ऑफ सुप्रीम कोर्ट ये क्वालिफिकेशन ये ओथ ये कुछ फैक्चुअल इंफॉर्मेशन है दैट यू हैव टू कीप इन योर माइंड सो फर्स्ट मेजर क्वालिफिकेशन इज कि दैट पर्सन शुड बी ए सिटीजन ऑफ इंडिया ये फर्स्ट मेजर क्वालिफिकेशन है दैट इज कंपल्सरी वी कैन नॉट अपॉइंट सिटीजन ऑफ एनी अदर कंट्री एज अ जज ऑफ सुप्रीम कोर्ट देन आउट ऑफ दीज 3 रिमेनिंग क्वालिफिकेशन any one of these qualifications you should fulfill. You should be a distinguished jurist in the opinion of president. Yeah, you have been judge of high court for not less than 5 years, or you have been advocate of high court for not less than 10 years. इन तीनों में से कोई एक क्वालिफिकेशन आप फुलफिल करते हैं प्लस यू आर सिटीजन ऑफ इंडिया विच इज़ कंपल्सरी क्वालिफिकेशन then you can be appointed as a judge of Supreme Court, and any such judge of Supreme Court takes oath in the name of allegiance to Indian Constitution, upholding the sovereignty and integrity of India, which is mentioned in Schedule 3 of Indian Constitution, जहाँ पे आप देख सकते हैं डिटेल में कि what is the oath of a judge of Supreme Court. Then what about term? So क्या जजेस का टर्म 5 ईयर होता है जैसे मेंबर ऑफ पार्लियामेंट का? नो, देयर इज नो फिक्स टर्म. देयर इज नो फिक्स टर्म फॉर जजेस ऑफ सुप्रीम कोर्ट. देयर इज नो लोअर एज क्वालिफिकेशन फॉर ए जज of Supreme Court, but yes, he holds office until the age of attainment of 65 year. Even before attaining 65 year, he can resign by writing to CJI. No, not by writing to CJI, but by writing a letter of resignation to President of India, or President of India can remove such judge on the recommendation of Parliament. ये प्रोसेस आगे जाके हम आपके साथ डिस्कस करेंगे. तो 65 ईयर के पहले भी आप एक लेटर ऑफ रेजिग्नेशन लिख सकते हैं, प्रेसिडेंट को रिजाइन कर सकते हैं अपनी पोस्ट से, या 65 ईयर के पहले भी प्रेसिडेंट ऑन द रिकमेंडेशन ऑफ पार्लियामेंट कैन रिमूव सच कंसर्न जज ऑफ सुप्रीम कोर्ट. सो पोस्ट रिटायरमेंट यू कैन नॉट प्रैक्टिस इन एनी कोर्ट ऑफ इंडिया, एंड पोस्ट रिटायरमेंट यू कैन नॉट होल्ड एनी ऑफिस ऑफ प्रॉफिट अंडर गवर्नमेंट ऑफ इंडिया और अंडर गवर्नमेंट ऑफ स्टेट, बट फॉर दैट पर्पज offices like governors of state, president, vice president, they have been exempted. So very recently Justice P. Sathasivam was appointed as governor of Kerala state, जिसको लेके काफ़ी डिबेट इंडिया में हुआ, but that office is not coming under category of office of profit under definition of office of profit act, and because of that they can be appointed as a governor, they can be appointed as president, they can be appointed as vice president. They can enter into politics also. They can become a chief minister also, they can become MLA also, they can become MP also. Very recently Justice Gogoi became one member of Rajya Sabha. So here I am saying office of profit they are not supposed to hold, but there are certain offices they don't come under category of office of profit. Such offices they can hold even post retirement. This thing you have to keep in your mind considering appointment of Justice Gogoi as a member of Parliament of Rajya Sabha. इस एग्ज़ाम के लिए, इस ईयर के लिए ये एक इम्पॉर्टेंट एस्पेक्ट हो सकता है कि what is the office of profit, what offices they are not supposed to take in post retirement years. So this thing you have to keep in your mind. And now another important aspect, just like हमने आपके साथ डिस्कस किया appointment of judges of Supreme Court, in a similar manner for this session I told you people at the very beginning, the second important aspect that I am going to discuss, that is removal of judges of Supreme Court. And with regard to removal of judges of Supreme Court, I try to divide it into 2 aspects. One is the constitutional provision, and second is about one act I will mention, that is Judges Inquiry Act 1968. So constitutional provision under Article 124 says that President can remove a judge of Supreme Court on recommendation of Parliament. बट ऑन व्हाट ग्राउंड? क्योंकि हमने आपके साथ रूल ऑफ लॉ में डिस्कस किया कि किसी भी पर्सन को अगर पनिश करना है तो कुछ ग्राउंड्स होने चाहिए, एंड ग्राउंड्स इन केस ऑफ जजेस ऑफ सुप्रीम कोर्ट इज प्रूव्ड मिसबिहेवियर एंड इनकैपेसिटी. सो ऑन दीज 2 ग्राउंड्स इफ पार्लियामेंट they recommend, then president can remove a judge of Supreme Court. So article 124 clause 4 clause 5, they deal with procedure for removal of judges of Supreme Court, and Constitution authorizes Union Parliament to provide by law procedure for removal of judges of Supreme Court, and as per this authorization, Union Parliament has enacted a law known as Judges Inquiry Act 1968, and Judges Inquiry Act 1968, it talks about detailed procedure through which a judge of Supreme Court can be removed. So these things you have to keep in your mind, that president can remove on the recommendation of what? Parliament. This thing is mentioned in constitution. कॉन्स्टिट्यूशन में ग्राउंड्स के बारे में बताया गया है कि ग्राउंड्स कैन बी प्रूव्ड मिसबिहेवियर एंड इनकैपेसिटी, बट हाउ टू एस्टैब्लिश प्रूव्ड मिसबिहेवियर एंड इनकैपेसिटी? with regard to that, Constitution of India is authorizing union power procedure for removal of judges of Supreme Court, and mind it, this procedure for removal of judges of Supreme Court and High Court both are same. ये आपको याद रखना पड़ेगा कि procedure for removal of judges of Supreme Court and High Court is same, and accordingly Parliament has enacted Judges Inquiry Act 1968. Then one aspect जिसको लेके बच्चों के माइंड में हमेशा डाउट आता है कि वेदर जजेस ऑफ सुप्रीम कोर्ट दे आर रिमूव्ड और दे आर इम्पीच्ड. सो इम्पीचमेंट वर्ड, if at all it is mentioned anywhere in Indian constitution, so it is mentioned only in context of President of India. So Constitution of India says only President is a constitutional dignitary who is impeached. All other constitutional dignitaries, they are removed, they are not impeached. But since Constitution authorized कर रहा है किसे? Parliament को to provide by law detailed procedure with regard to removal of judges of Supreme Court, and one such law was enacted known as Judges Inquiry Act 1968. इस act में mention है word impeachment. So in Constitution there is no mention of impeachment with regard to judges of Supreme Court and High Court. Removal is mentioned, but Judges Inquiry Act में it is mentioned that word impeachment with regard to removal of judges of Supreme Court. So what is the procedure through which Judges Inquiry Act says that a judge of Supreme Court can be removed on the ground of proved misbehavior and incapacity? So any such charges can be introduced in form of bringing a motion in either House of Parliament, either in Lok Sabha or in Rajya Sabha. So if you are trying to introduce or initiate such motion in Lok Sabha, minimum support of 100 members is required. But if you want to initiate such motion in Rajya Sabha, minimum support of 50 members is required. So that is a minimum support of member of Parliament just for initiation, just for introduction. पास होने के लिए क्या मेजॉरिटी चाहिए, दैट वी विल लेटर ऑन. सच मोशन कैरिंग सच चार्जेस, इट कैन बी इंट्रोड्यूस इन आइदर लोकसभा और राज्यसभा. In case of Lok Sabha, it can be introduced with support of 100 member. In case of Rajya Sabha, it can be introduced with support of 50 member. After proper introduction in either house, either in Lok Sabha or in Rajya Sabha, presiding officer of that house, he will constitute a committee, a judicial committee headed by a sitting judge of what? Supreme Court. But that judge should not be the judge against whom such motion has been initiated. He should be some other judge, then a Chief Justice of High Court, and third person should be a distinguished jurist. This 3-member judicial committee will be constituted by originating house, जहाँ पे ये charges initiate किए गए हैं. That 3-member judicial committee will investigate such charges against concerned judge, and then they will submit their report to speaker or the chairman of Rajya Sabha as the case may be. अगर charges सही पाए गए हैं, then such charges will be placed on the floor of originating house. Originating house से मेरा मतलब है कि जिस house में से initiate किया गया है, ये लोकसभा भी हो सकता है और राज्यसभा भी हो सकता है, इसे place किया जाएगा house में, but इस पर discussion start नहीं होगा. Before starting discussion, 14 days notice will be served to that concerned judge, that he should prepare himself for a defense. Either he may defend himself or he may take the services of an eminent lawyer. Once house which has originated it, after such proceeding, passes it with a special majority. And what is a special majority in this case? We have already discussed two-thirds of members present and voting, and by a majority of total strength of house. So with this majority, two-thirds of members present and voting, and by a majority of total strength of house, if originating house passes it, then it goes to other house, second house, and second house also, if it passes it with a special majority, then it goes to president. And if president issues such order, then concerned judge is removed from the Supreme Court. So this is the procedure mentioned under Judges Inquiry Act 1968, not under Constitution. ये बात आपको याद रखनी पड़ेगी. Constitution बस ये बोल रहा है कि President can remove a judge of Supreme Court on recommendation of what? Union Parliament, and Constitution authorizes a Union Parliament to provide by law detailed procedure for removal of such judge of Supreme Court. But Judges Inquiry Act 1968, that is one such act enacted by Parliament which talks about removal process of judges of Supreme Court in detail, and that I discuss with you people. कि अगर लोकसभा में इनिशिएट करना है तो मिनिमम 50 मेंबर्स, मिनिमम 100 मेंबर. इफ राज्यसभा में इनिशिएट करना है तो मिनिमम 50 मेंबर. Then 3-member judicial committee will be appointed to investigate charges against such judge. If charges are true, then it will be placed, report will be placed on the floor of house that has originated it. Before starting discussion, 14 days prior notice will be served to judge. He will be given chance to defend himself. After such process, if originating house pass that resolution, pass that motion by 2/3 member present and voting, and by a majority of total strength of house, then it goes to second house. And if second house also passes such motion, then it goes to president, who issues formal order for removal of such judge of a Supreme Court. And in Constitution, there is no mention of suspension of judges. So जिस जज के अगेंस्ट में मोशन प्रोसीडिंग चल रही है, जिस जज के रिमूवल से रिलेटेड ऐसा मोशन या इम्पीचमेंट से रिलेटेड मोशन ऐसा चल रहा है, उस टाइम तक क्या वो जज जुडिशियल प्रोसीडिंग में पार्टिसिपेट कर सकता है, क्या केसेस की हियरिंग कर सकता है, इसको लेके कॉन्स्टिट्यूशन में कोई मेंशन नहीं है. सो इन कॉन्स्टिट्यूशन में देयर इज नो सच मेंशन कि जिस टाइम तक उस कंसर्न जज के अगेंस्ट में प्रोसीडिंग चल रही है, दैट जज शुड गेट सस्पेंडेड. नो सच मेंशन of suspension of judges in Constitution, and because of that I am saying that concerned judge against whom charges are being leveled, he will keep on attending judicial functioning, judicial proceedings, and entire process should be completed within a single session. ये बात भी आपको अपने माइंड में याद रखना है कि इस पूरे प्रोसेस को एक सेशन में ही कंप्लीट करना है. देयर आर सर्टेन इंस्टेंसेस दैट यू मे फाइंड ऑन योर स्क्रीन. जब ऐसे रिमूवल या इम्पीचमेंट मोशन इनिशिएट किए गए अगेंस्ट होम जजेस, जस्टिस वी रामास्वामी इन 1991, जस्टिस सौमित्र सेन इन 2008, and very recently against Justice Deepak Mishra, who at that time was Chief Justice of India, against whom such motion was initiated in front of chairman of Rajya Sabha, but chairman refused to admit it, and it was the first time when any such proposal, any such motion was initiated against Chief Justice of India in last 70 years history. So that thing you have to keep in your mind, which is one important fact. I'm not saying from UPSC point of view, but from any state PSC point of view, they may ask sometime or other time. Then salaries and allowances of judges of Supreme Court, they are charged on consolidated fund of India. So just to maintain their independence, just to maintain their independent functioning, salaries of judges of Supreme Court, that is charged on consolidated fund of India, and it is determined by Parliament. It can be increased, but it cannot be varied to the disadvantage of judges of Supreme Court, so that they can discharge their functions in an impartial and neutral manner. So that is one small information with regard to salaries and allowances. So from this session I am saying, friend, two things are very important. One thing is how judges are appointed, and second thing that I discuss with you people, that removal of judges of Supreme Court. So these two aspects are very important from your examination point of view. In next session that I will deal with Supreme Court, I will discuss with powers or jurisdictions of Supreme Court. सुप्रीम कोर्ट के जो अलग अलग जुरिडिक्शन है, ओरिजिनल जुरिडिक्शन, appellate jurisdiction, writ jurisdiction, all these things I will try to discuss, and then we will try to discuss idea of public interest litigation, judicial activism. These are the important topics from your examination point of view, and then in next session of 1 hour I will try to wrap up this topic of Supreme Court. So I hope कि जो भी मैंने आज आपके साथ डिस्कस किया, you people were able to understand, and definitely you try to develop better understanding through this session. शायद इससे आपको मदद मिले और अच्छी कॉन्सेप्चुअल क्लैरिटी बनाने में विद रिगार्ड टू अपॉइंटमेंट ऑफ जजेस ऑफ सुप्रीम कोर्ट एंड रिमूवल ऑफ जजेस ऑफ सुप्रीम कोर्ट. इन नेक्स्ट सेशन आई विल कम अप विद jurisdiction of Supreme Court. Till that time you should revise this particular lecture, and there will be any doubt that